This is case number 254745 OD. We're here for an arraignment. Ma'am, did you have the opportunity to meet with somebody from the defender's office today? Mr. Harrison, or but she did meet with someone from your staff?
She met with Brian, yes.
Ma'am, I have a complaint that alleges that on or about November 8th, 2025 in the city of Cadillac in Wexford County, it is alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by a fine of not more than $500 and or 93 days in jail with an additional suspension or revocation of your license, vehicle immobilization, community service and rehabilitative programs, along with reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties? All right. That advice of rights form we mentioned earlier, did you read that form? Talked about your rights to an attorney and your rights to a trial?
No, Your Honor.
All right. So I'm going to go through those rights with you. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. You've been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with permission of the court, to have a trial by jury, and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to be able to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, and you can test your ability to pay the ordered fees if the court attempts to collect the cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those rights that we just went through. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days from the date of sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights?
Yes, Your Honor.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one will be appointed to represent you at public expense, but you may be required to repay that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointment of an attorney.
And what is your current source of income?
Social Security.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show any prior history, and the practice scores her at a risk level 0, and $250 bond was posted over the weekend. Mr. Harrison, any comment regarding bond?
I think the presumptive, the cash bond that's been posted is more than sufficient as far as the bond criteria. None of them seem to apply to her. She doesn't appear to be a risk, a flight risk. It doesn't appear to be a danger to the community at large. Obviously, the court would be within its rights to seek some form of testing, but I'm unaware of the presumptive BAC in this case, so I can't comment on that. I'll leave it to your discretion.
Thank you, Ms. Lawrence.
Thank you. This was a traffic stop that stemmed from crossing the center line and some poor driving. There was a PBT that came back at a 0.133. Given that at this time, the people would just have for random alcohol testing. Thank you.
All right, the court will continue the bond as previously set with the following conditions. Ma'am, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any alcohol, and you'll be subject to random testing. You can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the public defender's office, and then you'll need to go downstairs to the community corrections office to get signed up for testing. Okay? All right. Thank you. Person at the Wexford County Jail, please state your name.
Ethan Anderson.
I'm sorry.
All right, this is case number 254461 SD. Mr. Thomas, you appear on behalf of Mr. Anderson.
Sorry. Thank you, Your Honor. I, Thomas, on behalf of the defendant who is present via Zoom.
All right, and we are here for an arraignment on a bench warrant for, it is alleged that Mr. Anderson, you failed to appear for a random alcohol test as ordered on November 1st and November 2nd, and that you also failed to appear for a drug test as ordered on November 1st and November 2nd. Mr. Anderson, you do have the right to set this matter for a contested hearing where the prosecution would be required to prove the alleged violations, or you can plead to those violations, and I'll turn to Mr. Thomas. How are we moving forward today? Mr. Thomas?
Would you like, Your Honor, it's my understanding that Mr. Anderson intends to plead guilty to the bond violation.
All right. Ms. Lawrence, any objection to that?
No.
Mr. Anderson, is that your intent today, is to plead to the bond violations?
Yes, sir.
All right, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You put your hand down. Sir, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes, Your Honor.
Then to the allegations that you failed to appear for a random alcohol test as ordered on November 1st and 2nd, and that you failed to appear for a drug test as ordered on November 1st and 2nd, how do you plead?
Guilty, Your Honor.
In order to accept those pleas, I must have you tell me what it is that makes you guilty. So did you know that you were supposed to appear for testing on November 1st and 2nd?
It was the randomized testing, and I just woke up too late, and that's why I presume myself guilty. It's as charged. I didn't appear.
Okay. So you said you woke up late. Did you check your numbers to see if you were supposed to appear, or did you do that and just not appear?
I woke up late. I checked the numbers, and I realized that I was supposed to appear after testing had already closed on both days.
All right. And you realize that, or you knew that testing was a condition of your bond?
Yes, Your Honor.
Do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, sir.
Thank you, Your Honor.
All right. As does the court, I find the defendant guilty of violating his bond conditions for failing to appear for testing on the 1st and 2nd of November. That leaves us what to do with bond, Mr. Thomas?
Thank you, Your Honor. There is no other way to characterize this than a mistake. Mr. Anderson on the weekend was unaware of the testing times on Saturday, the weekend time being different than what they are during the week. And when it comes to the Sunday testing, Mr. Anderson uses a nightstand alarm clock that he sets for his alarms. That, as we know, it does not get automatically updated as the time changed on that weekend. I believe it was the day after or the morning of the time it changed. It's due to that hour pushback. Mr. Anderson had missed that test as well. I called this a mistake earlier, not to minimize it or to say that it's to reduce it in any way. I only use that language to say that with mistakes, we hope to learn lessons. And I believe Mr. Anderson has learned his lesson about the importance of the punctuality and showing up for these tests and doing them. As he spent the weekend in jail, he's here today, appearing via Zoom and not here in person as he'd like to be. I will add, Your Honor, to the argument at the end of, I believe, last week, or it was the week before, Mr. Anderson can correct me, but for his job that he is just starting, today's supposed to be his first day, he did have to complete a drug test. I'm not sure if it was with alcohol or if it was just drugs. We did have to complete a test for that employment. So he is not trying to avoid testing in any way. He's not trying to conceal anything. I don't have the results of that test yet. I had asked Mr. Anderson to provide that to me as soon as he gets them. He hasn't received them yet, so I don't have them to present to the court today. But with that in mind, we are asking that the court allow the bond conditions to resume as they originally ordered, or at the court's discretion, because Mr. Anderson can now afford it. If the option for a daily testing using a breathalyzer that he takes home is an option, as before he could not pay for it, now he can, and he would like to use that if possible, instead of the random testing and coming to the court in person. But that's at the court's discretion. I will leave it at that.
Mr. Thomas, am I accurate? We haven't even gotten to a pretrial in this case yet.
Pretrial scheduled for Wednesday, Your Honor.
All right, thank you. Ms. Lawrence?
Thank you, Your Honor. I am going to ask for remand in this case. Just to remind the court, the underlying operating while intoxicated, the defendant actually flipped his truck over on a curb, which is pretty serious, and the defendant is not even legally allowed to drink yet. Like the court just said, we haven't even gotten to the pretrial yet, and he has had multiple bond violations. It doesn't escape the people's mind that this occurred on Halloween weekend. He decides not to show up for 2 tests. I think given that, it's clear the defendant is not taking this seriously. So the people would ask for remand. Thank you.
All right, we are here on what equates to our 3rd bond violation. First one was back on October 28th. Defendant was placed on bond October 20th. So this is not his first, might be the first weekend he's required to test, but it wouldn't be his first time going through a weekend of testing and checking. Also, if I'm doing my math correctly, in the fall, we fall back when it comes time to setting clocks. So he would have been early, not late for testing. If it was 10 o'clock, it's now 9 o'clock, so he would have been early. I do find additionally that bond was previously set at $250. I've got somebody on a drunk driving charge on his 3rd violations for testing issues. The defendant will be remanded and bond forfeited. Next arraignment, jail. Did you have a question, sir?
Yes, Your Honor. Do I have a cash bond or?
Oh, you're being held without a bond at this point. Please state your name for the record.
David Reichenberg.
All right, this is case number 254738 SM, the people of the state of Michigan versus David Scott Reichenberg. Sir, you met with somebody from Community Corrections and gave them a mailing address, email, and telephone number. Is that information accurate?
Yes,
Did you have the opportunity to meet with somebody from the Public Defender's Office today?
I did.
I have a complaint that alleges that on or about November 9th, 2025 in Cedar Creek Township of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign an advice of rights form there at the jail, talk about your rights to an attorney and your rights to a trial?
Yes,
Do you understand those rights?
yes,
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Sir, today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointment of an attorney.
What is your current source of income?
I don't have one.
The court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 24 an attempted interference with electronic communications and an attempted domestic violence arising out of the same transaction. The praxis scores him at a risk level 5, so medium risk. Any comment regarding bond, Mr. Harrison?
Well, Your Honor, I was surprised to see a praxis of that magnitude from Mr. Reichenberg. He did acknowledge when I met with him this morning that he is a child support warrant out of Traverse City. As far as I can tell, there was also a failure to appear for a financial review.
Correct.
In this court, I believe, and that's all that came up initially, so. I understand the way the praxis scores. I understand that this score looks a little bit worse than I think the reality of the situation actually is. I don't think it's a flight risk. Despite the failure to appear for a financial review. For me, treat that otherwise, it's just my opinion. I think it's a good candidate, PR or a nominal cash bond. I would have you set some sort of bond here because of the situation with Traverse City. I don't know if they're gonna come and get him, or if they're holding him right now or anything like that. So that appropriate credit can be doled out when all is said and done.
Thank you, Ms. Lawrence.
Thank you, Your Honor. The people would just ask for a no contact order with the victim at this time.
Mr. Rittenberg, how do you support yourself without being unemployed?
I do have food stamps, and whenever I do go up to Traverse City, I'm planning on trying to get into the homeless shelter up there if I can.
All right, if I release you, is there anything that's going to stop you from coming back to court?
No, sir. If I get into the homeless shelter on up there, I would talk to the people to see what they can do to help me to make it to court on time. Or figure out a way to show myself in front of you.
All right. Well, sir, I am going to release you on your own personal recognizance, which is your promise to come back to court with the following conditions: that you appear as ordered, not leave the state without permission, and commit no new crimes. I'm also going to order that you not have any contact with Ariel Wisniewski, that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. Do you understand those bond conditions?
Yes, sir.
No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your own behalf. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, sir. I don't have her on Facebook, phone number, or any of that.
All right. Now, on your other case, the case that you were here for last year, you currently owe the court $772. Are you able to get set up on any type of payment plan at all for that?
I'm currently I had a job interview on Friday, and I'm waiting to hear back from them. And if so, one of my paychecks will be going directly to you guys.
All right. So what I'm going to do is I'm going to reset this then for a review hearing in 3 months. All right. So
Okay.
before you leave the jail today, you'll be getting your next court date for your new case, and you'll be getting a court date for that financial review hearing, all right?
Yes, sir.
All right, and also, if you find out where you're going to land and get a new mailing address, let us know that, okay?
Right, if I'm in Traverse City, sir, the mailing address will be 222 Cass Street, Traverse City, Michigan.
Okay,
That's where
well, if you,
the mail should be able to be sent to.
all right, well, if you end up going to Traverse City, let us know that, and we'll start sending your mail there, all right?
Yes, sir.
All right, thank you. Next arraignment, Jail?